Policy Committee meeting on August 18th of 2020 at 3:30 p.m. to order. Today we have Policy EGAB, Intellectual Property and Copyright, followed by Policy KDD, the Media Relations, and an update. We will also hear an update from our policy and regulations impacted by COVID-19. And so with that, I will tee us up.
Cool. Thank you very much. My name is Sally Robinson. I'm with the Office of Legal Counsel, and I will be presenting to you today information regarding our proposed policy on intellectual property. So just to let you know that this is a brand new policy. It does not replace an existing board rule, but however, there is some existing language in one of our other board policies, policy EGD, which deals with technology and acceptable use, and the regulation EGD-RA. They both do contain some language regarding intellectual property. Policy EGD has language actually regarding fair use, saying that city schools technology will comply with licensing and fair use agreements. And there's also additional language in the policy that says users of city schools technology cannot or must not violate laws that we have to protect copyrighted, patented, and trademarked equipment, devices, and data, information, and material. It also states that users shall not violate terms or conditions of software licensing agreements that we have entered. In the regulation EGD-RA, there's also some brief language regarding the concept of work for hire. It says that all email, equipment, and documents created, composed, stored, transmitted, and/or received are and remain at all times property of city schools. So mainly the purpose of this proposed policy is to provide more detailed guidance to staff and students regarding complying with intellectual property rights, most especially copyright. And the timing of this policy is also very important and relevant to our current situation that we're getting ready to start in a couple of weeks, with the virtual or online learning. Because under copyright, there are certain options that are available to districts and educators in online learning that are still compliant with copyright law while making content available to students. And one of the things that we have available to us is the TEACH Act, which I'll be talking about in some depth, and also the use of licensing materials that we already have, and also fair use. So we can go to the next slide. So basically, just quickly, some basics of copyright. In the policy, we set forth some basic ideas or principles, that it's the protection of rights of authors and creators of original works. Those creators and authors receive exclusive rights to control how their work can be used. And in some instances, like I said, city schools might have procured a license to use copyright protected works. But it's important to note that in some instances, or a lot of times, those licenses will have restrictions, such as the work can only be used for educational purposes. So in this time of online or virtual learning, city schools really should be, and I'm sure it already has, review the existing licenses that we have to see whether they extend to distribution in electronic form. And the policy also sets forth the certain works that are not subject to copyright protection, and those include things that are authored by the federal government and also works authored prior to 1923. So next that we cover is fair use. So I'll go into a little bit more detail about that in a bit when I get to the administrative regulations slide. But fair use, it's fairly well known. Most folks have heard of it. It's a limitation on the exclusive rights that are granted to copyright holders. So it was created initially in case law, but it's since been incorporated or codified into the Copyright Act itself. And in certain circumstances, it allows an educator limited use of copyrighted materials without needing to get permission from the right holder, the copyright holder. So typically what happens is a copyright holder, for the case law that was developed, typically what would happen is a copyright holder would accuse someone of infringing their rights and using their work in violation of the exclusive rights that they hold. So then the accused would then argue in their defense that their use was fair. So there are 4 basic factors that have been created over the years in all the case laws. So 4 factors that the judges will take a look at or evaluate. And so it's the purpose and character of the use, including whether it's of a commercial nature or if it's for a nonprofit educational purpose. The second factor is the nature of the copyrighted work. The third is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And then the fourth factor is the effect of the use upon the market or the potential market for or the value of the copyrighted work. And what makes fair use tricky and complicated is that there aren't any bright line rules. Each situation has to be evaluated based on the unique factors in that particular situation. So I'll talk about some examples in a few minutes when I get to the regulation. The next tool that we have is the Teach Act. So that was added or enacted in 2002 and added to the copyright law itself. So the idea behind this was to remove impediments to the use of new technologies in teaching. And because before 2002, electronic transmissions of copyright protected materials typically or generally fell outside of the education exemptions found in the copyright law, because those exemptions that are explicitly limited to face-to-face classroom settings. So the Teach Act basically expands an educator's ability to use works that are copyright protected, but in a digital teaching materials without first obtaining permission from the copyright owner. And it covers materials prepared for at-home use by students enrolled in the course, taught in traditional classroom settings, as well as in distance learning courses. And there are also, as I set forth in the regulation, there are numerous criteria that have to be met in order to use the exception. So I will go into those details again when I get to the regulation. So next slide. So next up is works made for hire. So as I mentioned before at the outset, there is some language in Administrative Regulation EGD-RA about the work made for hire concept. But in this new policy and regulation, however, we've gone into more detail. The language and also the board should know that the language that we've included here is consistent with other jurisdictions' policies on work made for hire, including Baltimore and Montgomery counties. The basic premise of a work made for hire is that an employee creates a work within the scope of their employment. The board is the owner of that work. I'm sorry, my email's still on. Additionally, the language in the policy provides that supplies, equipment, or materials created by an employee or employees in which they use the district's time, facilities, materials, etc., and as part of their job responsibilities are, again, it's the board's property. And additional details about how to analyze those factors are, again, found in the regulation. The next topic is student work product. This is actually based on Maryland law. The law says that the board cannot claim ownership or copyright student work product. It says that if a student's intellectual property is published, a copyright notice must be affixed to it. Also, we provide students and parents with the opportunity to opt out of their intellectual property being published, displayed, or reproduced. And that's done on the annual directory information and media opt-out notice that's done every fall. In the implementation strategy, we've included language that we will be including in our contracts and MOUs that will safeguard intellectual property rights with our language in our contracts with vendors and others who provide services or supports to our students. So if we go to the next slide, we'll start talking about the administrative regulation and going into more detail about the various factors with the exceptions. So the regulation starts out with fair use and how the 4 factors are analyzed. I'm going to focus on the first one and the fourth one because those are typically the ones that the courts focus on more heavily. The other thing that we plan on doing here, because this is so tricky, is in time for the first reading, we'll attempt to create like a tool or some additional instructions, maybe akin to like a worksheet or a cheat sheet to assist teachers in making these determinations as to whether or not their use is fair. And we might also include a form or some method for the teacher to document their instances of fair use. So the first factor is the purpose and character of the use. It's really discussing here how the work will be used. So typically here, judges are going to favor use that is not commercial, that it's educational, scientific, or historical. But we also have to keep in mind that some educational or scientific use that is for a commercial purpose might not be excused by the fair use doctrine. So an example would be, let's say somebody used an image of a painting found in an art history book. That would be likely be deemed fair use if you were making a scholarly commentary on that that painting. But if you were to take that same image and use it on an advertisement for an unrelated product, that would not be fair use. Another example in this factor would be a teacher photocopying an entire novel for the students in the teacher's class. That would not be fair use, even if it were an educational use, because it was the whole novel.
Hello.
The fourth factor, again, I'm skipping the second and the third. The fourth factor is the effect of the use on the potential market value of the copyrighted work. So really here what the courts are looking at is what is the economic impact on the work. So the intention here is to strike a balance between the benefit that the public will derive if the use is permitted and the personal gain that the copyright owner will receive if the use is denied. The considerations here can also go beyond the original creator or author's past intentions or the means by which they are currently exploiting their work. An example here would be, let's say, a photograph. Someone took a photograph and they adapted it to a wood sculpture. The court, in this particular case, the court recognized the existence of a market for the new version or use of the photograph, that wood carving or that wood sculpture. And they held that the unauthorized use of the photo in that new method or new mode undermined a potential market to the original copyright owner. So the regulation also contains information regarding classroom copying of books and periodicals and music. So I can go into those if you like, or I can go on to the Teach Act. The Teach Act, as I mentioned earlier, there are numerous conditions or criteria that have to be met when we rely on the Teach Act. They're all listed in the regulation. Some of them are that the material in question has to be provided under the direction or the supervision of the teacher, the instructor. Also, the material has to be integral to an integral part of the curriculum. So it can't be something that's just being used for entertainment or some kind of unrelated background material. Also, the amount of material provided has to be comparable to that typically displayed in the live classroom session. So here, some works, the display of an entire work could be consistent with displays typically made in a live classroom setting. For instance, short poems or essays or a non-dramatic literary work. But what we can't do is distribute an entire textbook, course packs, or supplemental readings. Some of the other criteria or requirements is that notice has to be provided to students that the material being distributed is subject to copyright or is protected by copyright, and it's limited to only the students that are in the course. Other things with the Teach Act that it doesn't authorize is the use, and this one is confusing a bit, but it does not authorize the use of works specifically created as distance learning products. What that means is if you don't use materials that are normally licensed for online courses, for those materials, we have to have the appropriate license. Also, and this is fairly basic, but it does not permit us to use works that we have reason to believe are pirated, not lawfully made. And this would include many copyright protected films and a lot of the music downloaded from the internet. Next slide. So additional information on works made for hire. There are some factors that have to be considered when we determine whether or not something is a work made for hire. The first one is, does the board or city schools have control over the work? Meaning, was city schools equipment used? Was it done while the employee was on the job? Second factor is whether or not the board has control over the employee. Meaning here is, does city schools control the person's schedule when the work was made? And does the district determine how the employee was paid? And the third factor is what the board's status in the nature of the scope, what is the board's status in the nature or type of work created? Meaning, is city schools in the business of producing such types of works? Next up is requesting permission. Just quickly, this is a short section advising that in some situations, permission is going to need to be sought from the copyright owner because we don't have a license, we can't do fair use. Teach Act doesn't apply. So the form referenced in the regulation is still being created and might also include a review and approval process. And next up is claims of copyright infringement. So this section provides information to copyright holders who believe that city schools has infringed their copyright. So there are certain steps or instructions that are laid out in the regulation, including, for instance, identifying the material that city schools is using that the copyright owner believes is the subject of the infringing activity. And then last is showing movies in our schools. So movies that are shown in conjunction with the curriculum are permissible. So for instance, let's say, and I'm going to show my age here with these examples, but let's say, for instance, a history class is studying World War II and the Holocaust. It would be acceptable to show the movie Judgment at Nuremberg because that's associated with that curriculum. However, if a teacher, let's say at the end of the school year, wanted to show something like Beverly Hills Cop because the teacher is appreciative of the students' efforts during the course of the year and wanted to reward them for good behavior, that would not be permissible unless the teacher or city schools had obtained a public performance license. And next up, or just next steps in the next slide, the draft has been shared with media and instructional technology to take a look at and provide feedback. I also recently, I haven't reached out yet, but I recently received the contact information for the new head of PCAB and will be sending the drafts to that individual to try to get onto their agenda as quickly as possible. And also to add to this too, the communications team has recently provided feedback on the drafts earlier this week that we will be able to consider. And I also look forward to cooperating or collaborating with Mr. Riley, because I know he's got experience in dealing with copyright, like seeking copyright permission. So I will look forward to collaborating with him on that form that we're building. And that's it.
Great. Thank you so much, Sally. I really appreciate the presentation. So what I would invite us to do, commissioners, if you have some questions, to just move into a question phase before we move on to the next policy review presentation.
I don't have a question, but I do have a comment, Sally. One thing that caused a red flag for me right away was when you talked about movies and your second example. And so I'm hoping, since this is a new policy that's coming in terms of really helping people to understand that piece, I just know from visiting schools that movies are used in a variety of ways that will not be following that policy at all.
Okay.
So just like I said, it's just a flag. I mean, you gave a great example of a reward if kids have been good kind of thing. I'm thinking of times I've seen them in the cafeteria as something to show after folks have eaten. I've seen them used, as you mentioned, as rewards. I have my own young folks that will say they don't want to be in school the last days of school because all they do is look at movies while people are doing some closeout things. So I know, and I'm a retired teacher, but I'm just saying we need to really, that's a big red flag. And I don't want us, if it's a policy, then to be caught in having, use violations come up. So just thought I just had to say it. Sorry about that.
Yeah, that's well received. We actually received I can't remember how long ago it was, but we actually did receive like an email from one of the license holders that, there are certain companies out there that own licenses to these movies, and they will sell them to you. And they basically said, hey, you only have one school in your entire district that has a license. So we're presuming that you're probably violating this. And so we would like to make some arrangements with you. So that is definitely an option out there. There are several companies that the district could work with to procure that license so that those movies would be acceptable.
Great. That was the only thing came from me.
To Commissioner Chinya's point, are we able to specify that in the regulation? Would that be a possibility to specify that
About
with
working
the
with
movies?
a company? Sure.
Just to be a bit more to be as clear as we possibly can be, because I get it, I understand. I have two questions. And just one comment, Dr. Brooks. Are we able to include more information about student work products in the regulations? Potential examples of student work products to perhaps give people a bit more information on how to handle that. Does that sound okay?
Sure.
Am I making sense? Okay.
Yep. This is the place to do it. I mean, if folks are going to have questions, we want it all to be like one-stop shopping. This is where they go to find out. Yep.
Yeah, I just think that needs to be clear, because if an employee, which I also think employees should be defined in this policy, who are they? I think about perhaps a contractor, right? Just hypothetically, would a contractor be considered a city schools employee, and would we retain rights to any of their work? Are you following the question? It's difficult for me to.
Yeah, so actually, yes. So that's probably going to, and Josh can back me up on this, but that's probably covered in the language that we put in the implementation strategies, where we'll include language in future contracts and MOUs that spells out Like if a company is providing services to city schools, it will lay out or clarify what remains theirs and what becomes ours.
So that would be more. Go ahead.
I'm sorry, and just to add on that, because it's directly to that point, we're trying to make sure that the contractors know as part of their contracts that they have to respect the student work product issue, so that they're all clear and can't say afterwards to us that they didn't have notice. So that's a really good point.
I appreciate that. And then finally, the question, at the end of the regulation, this is in showing movies, letter H, the same place that we were just talking. Who are licensed vendors? Who would licensed vendors be in regards to number 2 in letter H, showing movies?
I don't remember off the top of my head. I don't remember the names, but it's. I mean, there are national companies. I mean, I can go back and look at the memo that I did that lists like 2 or 3 of them. I mean, you can Google it and find them. It might be something, I just remember, like, you know, license something of America. There was definitely, but we can find them, and we can even, I don't know if it would be fiscally, if it would make sense for each school to do it on their own. I think more realistically better would be for the district itself to procure a license for all schools. That's probably going to be more cost effective.
Yeah, the reason why I ask is because if it is in the regulation, if licensed vendors are being referenced in the regulation, I know that there is a list of them, and I don't know if in this policy regulation if we need to be as explicit about where to find those vendors. But I just don't want us to be caught up in any, of course, you know, legal drama or copyright infringement issues because of it. So it's just the reason why I asked the question. Is there a list? Where do we find them? And it sounds like you all are going to include that in, you know, implementation guides. So I appreciate that. And then finally, for engagement, because I know as a fine arts teacher, as a music educator, this often is, it becomes an issue. Not having the money to buy adequate copies of, you know, copyrighted music, and the example that you referenced earlier with the sculpture and the photograph, I would recommend in your engagement process before it comes to first reader to reach out to the Office of Fine Arts and to have fine arts teachers a part of this. I would love to hear their feedback as a result of them being engaged with this particular policy, because I'm sure that they have quite a bit of insight as to how they're already going about it, but, you know, to inform us on how we can best support teachers in making sure that they have the resources that they need legally to support our young people.
Okay.
So that was it. Particularly music teachers, I would encourage some engagement.
Okay.
More engagement, intentional engagement around it. That's it for me.
Okay, thank you.
Great. And I have a few questions. Let's go back to the document. So I'm going to try to start making some weaving things together. One of the, picking up on what Commissioner McFadden said, I know that at the university level, we have digital libraries that the university students have access to, which houses movies, documentaries, and films, and of that nature. So the license, so the entity has it, and the license, a teacher or student can access that video library, music library, etc. And I think that's Cornucopia or something like that, Cornucopia, whatever the name of the entity is. My question for us, in just thinking about this policy, do we have or anticipate that we would have instead of having all individuals, that we would procure a license or a company to license with that houses movies for that are fun and interesting, and not just for the purposes of curriculum development, so we wouldn't be in an infringement place around a movie like showing Armageddon, or what's the big name, any one of the big blockbuster films.
Yeah, like 4th of July type of, yeah.
Yeah, so like, and so that was kind of my thinking around as a possibility. And I didn't know if you had thought about that or where we ended on that.
Yeah, I mean, I've thought about it in the sense that, like what Commissioner Chinio was saying, that, I mean, we can look into the financially, you know, what is it piecemeal? Like if Dallas Nicholas wanted to get a movie to show right before Thanksgiving, what would a one-time license be, versus if the district got one for every single school? That's probably going to make more sense, but it might also, I mean, it sounds like it happens a lot based on what Commissioner Chinny was saying, and it probably does. So I would imagine most schools do show these types of movies. So it might make sense once we look into it to get a license for the entire school district. And then what we could do in the regulation is either indicate that we do have a license, and rather than, I mean, we have a couple of options. We could actually say in the regulation who that license company is and how to contact them or how to obtain a movie from them. Or if it's possible that that deal might change periodically and we go with a different company, then we might have that listed somewhere else where we could periodically update it without having to come back and change the regulation, if that makes sense.
Yeah. So thank you. So I'm just going to try to group these together. One of the things that I noticed in this, and probably because it's in the development phase, was around how do we use policy in the affirmative? So to move not just about compliance, but also about sort of like really providing a place for people to know how to do something. And so, and whether that's in the regulation or the policy specifically, but most likely it'll exist in the regulation, to give those concrete examples of where, how to actually do something. So it's not just enough to vet your particular piece of curriculum. So when you said you might create a one-pager to help people do that, that's where my mind goes, because I'm thinking, like, I need a teacher or a person trying to implement this to be able to assess for themselves whether or not this thing is an acceptable approach or behavior, and then to make that easy as possible for them. And so that was kind of one of the pieces around affirmation and sort of, and I didn't know if that conflicted with sort of some of the more regulatory compliance related measures. So.
No, that's the plan, is to give teachers like step-by-step instructions, almost kind of like I said, like a worksheet, so they can kind of work through the analysis on their own with the necessary supports. And there also is the I can't remember, the Media and Technology Office is also a good resource for folks if they have questions.
And I think that, sorry to just jump in, I think that making sure that we include in the policy in the regulation where to go for resources, so people will clearly understand who they can get support from, in addition to just other teachers, given that this is a tricky area sometimes.
Absolutely. And could someone explain to me what our, it says in the policy, and just right at the purpose, the board will protect its own trademarks from unauthorized use. Sort of what is an example of unauthorized use from our perspective, and how do we go about protecting them?
So actually just did one recently. So we've had this occur off and on over the years. So most recently, the local Walmart store, someone discovered, is selling T-shirts that say Patterson Clippers on them. There are gray ones and there are blue ones, and they don't have a deal with the district to sell those items. And so we sent a letter just yesterday, actually, to their resident agent saying, you must cease and desist making these items, get rid of all your supply, etc. We've had instances in the past where I think it was called Web Candy made like little sweets and little tins and stuff, and they had, I think it was Dunbar, Mervo, Digital. They had all of their school names, school colors, logos. They were selling lip balm, candy, gym bags, T-shirts. So we let them know, you do not have the right, exactly, you do not have the right to use our trademark. That is our trademark. And what apparently, I think what happens is folks think that we have to register it, but we don't. There's an exception in the Lanham Act and under common law that that we do not actually have to go through the official steps of registering it. So that we do have to do that in our office periodically.
Great, that's helpful. And so that brings me to the thought. So when we do thinking about this policy, when we have a Spirit Week and we have young people creating some of their own content and sort of, if they start selling and distributing that, does that put them in breach of that particular agreement for city schools, or
yeah, it shouldn't, because if it's their work.
Okay. So,
I mean, we couldn't, the board, the city schools would not be able to claim ownership. So the students are a little bit different from the employees. The employees, if they are creating something while they're on the job, during the course of their employment duties, whatever, that's a work made for hire that the board owns, unless we work out some kind of other arrangements with them. But a student, per state law, we can't claim the copyright or the ownership of their product.
But I think Commissioner Brooks was also saying, well, if they use the logo of one of our schools in their Great Week piece, then I think that we would be, we'd want to be clear that they have permission for the limited purpose of the school. But if they turn around and start selling it at a Walmart or to the general public, that would be very different than something specifically for a team, a specific team or a specific event, right? So we're just very clear on the limits of the permission. We don't want to get in the way of schools celebrating and supporting Spirit, but we also want to make sure that that then doesn't become some license to a national retailer to market wares.
Yep.
Both for our protection.
Misunderstood. Yep.
And for our protection and for the students' protection.
Great, and I think that goes with, so from my mind, I immediately went to people are creating these beautiful things to wear, and then they're generating them as fundraisers for their particular programs in their institution. Just want to make sure that the young people, if they're doing that with our logos on it, that they're not in, we're not going to won't conflict with another policy that would make them be in violation of something, and or contradict something that we already have on the books. Great, so thank you for that. One of the questions I had was, the board, we see procurements for items over $50,000. And so what happens when a school procures individually or something under that threshold? Who then is responsible? Because it says that the CEO is the designee for any sort of, let me get the language right. It says, how do we ensure? Oh, go ahead.
Are you in the policy?
Yes.
Okay.
And so it says that 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 we have to sort of obtain certain permissions from the CEO. If it's happening at the school level, is it still the CEO or is it the principal that would need to be in consulting with around the intellectual property pieces?
Are you talking about like in the work made for hire section?
So
I think you mentioned like procurement. So I don't want to take us down the wrong rabbit hole, but principals technically don't have the right to procure. So depending on the dollar value, that would be actually the director of procurement. But I'm not sure that I don't think that's your question.
No, so like it says, I'm looking at the purpose in B. It says using copyrighted protected materials in the classroom, obtaining permissions to use these works for instructional purposes, outlining expectations for all board employees and students, and so forth. And then later on down the policy, it says when there are like moments of question or inquiry around sort of what is or isn't acceptable, you get the CEO is the ultimate. Let me make sure I'm capturing this correctly. We all have the agreement, especially when there needs to be an agreement made.
Are you in the policy, Dr. Brooks?
Yes.
Are you
Are
on the
you
like
in
the
section 4 and number 4, Roman numeral 4, implementation strategies?
Maybe, because I just think I made notes all over the place, but let me go back down. Yeah, so we works for hire. So you get to
I think it's B and C in number 4 of implementation strategies. I think that's what you're referencing, where it says the CEO is at administrative regulations shall include guidance, and then, or maybe that's not it. If you're looking for permission, I don't see anything in the policy that speaks to permission.
So,
I think
I'm thinking that as before first reader, we can also specify the order in the regulation, the ordinary places where people would go, just so we're clear on what is the typical office to which they go for permissions, if that makes sense.
Yeah, I think sort of what I was trying to get at is that like they're in terms of like copyright and the licenses, if they're happening at a level, at the school level, who's tracking them, and then who gives permission for those things. And so if it's a district-wide, we know that the CEO would then, you know, she's our CEO is the person that oversees our copyright, you know, essentially that if something happened, it would be the district responsibility. So is it the same for a sort of a district-wide purchase versus a school purchase? And then who's responsible if it's at the school level?
So let us clarify that in the before first reader, so that that's clear.
Right, but generally at the school level, the principal is acting as the designee for the CEO, since the line in terms of responsibility goes from the principal up to the CEO. So if that's what you're saying in terms of the different levels, when you get to the school level, the CEO's representative is the principal.
Okay.
But yeah, like Josh said, though, we'll make additional clarifications as to like who the resources are that staff can go to.
Great. And I had a question about, and I think it's all tied together. So for example, we have pieces of curriculum, the Be More Me curriculum, that was generated in collaboration across entities. So it was some teachers, it was some CBOs, and I'm trying to figure out, so then who owns that thing? And if there were any agreements that were made between us, where would they be housed, just in case there was a challenge to the use of that curriculum?
So if hopefully, I mean, you said it was between staff and
so it's
community-based organizations, CBFs. Okay, so hopefully there is an agreement that includes language similar to, or just like we put in the implementation strategies, that actually does set out and clarify who the copyright owner is of that work. So it would live in that agreement, which would be in procurement.
Great. And so is there any way to check to? Because I mean, I think one of my concerns is that I feel like we're going to go and try to do, you know, I think doing homegrown interventions or curriculum creation is beautiful, but I'm not sure to what extent agreements are being discussed around ownership, and just want to make sure that we're in compliance with.
Sure. And you said that was the Be More curriculum?
Mm-hmm.
Okay.
Yeah. Or maybe it was the CBO who owned it. I don't know. I just am not privy to that back end stuff, but I just wanted to flag it for us.
Okay.
And then I just had a general comment about the regulation. And so, let's see. When we get to regulation 2F, and it says the email, and I wasn't sure if, for me, I interpreted that to be, it says website at BCPS. If it was only for website specific things, is there a way to rename that so it's not like just a blanket like website, so that it's clear that it is actually, okay.
Okay, yeah, yep. It's at the top of the top of the last page.
Mm-hmm.
Yeah. Yeah, so yep, we'll clarify that.
And given that this is like, I think it might be on the more legal side, but I don't know if we need to have any language around sort of due process. Like if someone says this thing is copyrighted, we disagree. for a teacher, like, does this impact our any of the challenges that might come through us as a board in terms of any ethics or anything like that? So I'm not sure if we need a teacher or a principal to, if something would happen and we have to figure out how do we do a process that doesn't jeopardize sort of them or whatnot. So I don't know if we need any language about that in there.
Okay.
But I think it would pick up our standard. So I'm assuming you're in the case where we have somebody reach out and say, you're violating my copyright. And so we would likely do initial work just to see if they were similar, and then we'd probably initially take it down just to protect ourselves, and then we do an investigation through our staff investigations office to determine the circumstances of that. We'd probably pull in our media team because they have expertise in documents, and then based on that may come up the channel, but it may be as it turns out, an absolutely inadvertent piece, and we could, or it could turn out also that we do have the copyright to it, or our staff have the copyright to it. So that, yeah, absolutely, that would have to be investigated. But the trick in these cases is to protect yourself immediately so that you don't build up the damage and then do the investigation.
Great. And I just didn't know if in the regulations itself we needed to outline that so that people, if they knew anything, that we could be really clear with them about what was going on there.
Sure.
Yeah. And I think that was my last question. Tracking. Oh, one other thing. So for the work for hire section, it says, was the work done with city school equipment? Where's the work done as at the employee's job site? Given that we're at home now for COVID-19 and work getting done, like, so how does that sort of begin to factor in? And does that criteria still measure up given our current moment and COVID-19?
So it's just one of the factors. So I think when you look at the totality of all of them, if that's the only thing that is not weighing it aside that it's a work made for hire, then my opinion is we would argue that that's still a work made for hire, just because you're still doing your job. Just, we're being forced to work remotely at this point in time. So I would argue that that's that would it would still come down, weight on the side that the board it's a work for hire, made for hire.
Great. And I think what that former piece, which was if we also give people computers to do their jobs, so I'm assuming, are you saying that follows along with that? So then they're both using a product that is the city school's property and they're doing it at home? Are we?
Yep, I think it's exactly another factor to consider. Yes, it's part of the same analysis. Okay,
great. And then also I did see stuff around, given that we're in a new age around social media, blogs, we're in an age of influencers and using different social media platforms. What does if something is shared via Facebook, a piece of entertainment or information using that platform, does that impact any of the a teacher's role or capacity in terms of violations? So if they just pull up a website and use it on a different platform, but the content is still something that's protected under copyright, does that get them into is that different, or does that still get them into trouble?
It's probably still going to get them into trouble because if they're like showing the entire thing, it's like fair use. It's only I guess it depends. We'll go back and look at one of the factors, but let's see which one. The amount and substantiality factor comes into play. Is it the whole work? How much is it 250 words of a short essay? Is it 2 or 3 pages of a short poem, or is it the entire work? Just because you're maybe attributing copyright to somebody else doesn't mean it's fair game.
Mm-hmm. Yeah, and I just pointed that out because I also know that folks might be using different platforms, and so do we need to name that they're in this world of social media now and different platform and technologies? Does that need to live inside the document, or at least the regulation, to know that people aren't safe because they use one form of media or to share something versus another? So I didn't know if that also needed to be sort of thought about and sort of considered in terms of regulation.
Yeah, I think I'm not sure if I want to if we put it in the regulation or maybe in the worksheet that we're developing. But I do think it's a good idea to include. So I just have to figure out what makes the most sense as to where.
Yeah, great. I just know that we're in a different space, so
yes,
try to get everything in there.
And that's to your point.
Oh, go ahead.
To your point, Dr. Brooks, I think we should also, just be explicit about the fair use, what that means in the implementation guide that you all are talking about, because I think that could also support what Dr. Brooks is rightfully getting at. I think about, for example, like if I was listening to a podcast or something, perhaps like say The Breakfast Club, and they showed some media within that particular show, and I'm on my social media and I decide to pull that up and broadcast that, to my class, what particularly goes into fair use and what doesn't. I just think it needs to be explicit. And then finally, because we've talked quite a bit about principals, and them being CEO designees and things of that nature. I know that they deal with these instances more than most people, so I think they would be a good group to also engage in the process prior to first reader. And just to be clear, a conglomerate of elementary, middle, and high school principals.
Yep.
I think that would be important.
Great. So any other questions before we move on to the next policy?
Thank you very much. This is really great feedback.
Thank you so much. We really appreciate you being here. And so we're going to move on to the media relations policy KDD.
Greetings, board members. Greetings, colleagues. I'm Andre Riley, the Director of Communications for City Schools. My chief, Tina Highcover, sends her sincerest apologies. She had worked to hold on to be a part of this meeting, but she had to run. So she left me here to fill in, and I'm going to do my best to explain to you the proposed policy KDD, media relations. Before we talk about the why of the policy and some of the functions, I just want to give you a quick overview of what media relations means in city schools. So you see 4 big numbers on the screen: the number of media requests we received, the number that of news releases we sent out, the total number of media outlets we work with, and how many times we pitch to media a month. We are a fairly active organization when it comes to our interactions with all media, that being local, state, and national. So if we have this level of activity, we want to create some guideposts so we can have great relationships with media while also giving staff the tools that they need to have effective responses when members of the media reach out to us. Next slide, please. So again, our desired outcome is to develop effective working relationships with media professionals and student journalists. And we want to include student journalists because we have newspapers, we have blogs, we have other items that our students contribute to, and we want to help them get real world experience. So we want to create pathways that we treat them just the same way we would treat, well, not the same way, but in a lot of ways in a very similar manner to how we treat media professionals. And again, the goal is for clear boundaries. Once we have those boundaries, we're able to make sure that we have accurate and transparent responses. Right now, when you have the level of media activity that we have, if a member of our organization, an employee, decides they want to respond to a media request, their answer may be different from mine on the same topic. And my answer may be different from your answer. So there's no accuracy and there's no clarity in that. It's just a bunch of different people talking. So we're trying to set up a pathway where every time the media works with us, we're accurate and we're transparent and clear. And that helps to build our relationship with them. Again, we want to build structure. We want to make sure that we're providing publicly accessible information. We strongly believe in being a transparent organization. We are responsible to the public of which we serve, so they need to be able to have great information from us and access it and talk to us. So this policy allows them to get information through media that supports those outcomes. We want to be contextual. If you ask me a question about our schools, I want to ensure that the media is speaking in the proper context about them. For instance, you may say for our schools, every school is full of affluent individuals. Well, that's not the proper context of Baltimore City or a school district. The context is we have a wide variety of social economic statuses in the organization. So let's talk about the district in that. And finally, a mutual understanding. One of my superintendents once said to me, the best thing that two people can have is an understanding. Right now, we don't have anything in policy or written in our procedures that really sets out that mutual understanding about how we're going to interact with media. And that does not help us to maintain that effective working relationship that we would like. Next slide, please. The scope of policy KDD in this regulation will apply to all employees of city schools. This is no matter if you work for a charter school or traditional school. If you are a bona fide employee of our organization where we pay your salary and you're assigned a position, this policy applies to you, as well as to members of the media who work with us. And I'll talk a little bit about that in a second. In this policy scope, we get to the crux of that ability to want to deliver accurate information. And we do that by setting forth who responds to media requests, who has the ability to speak on behalf of our organization and who doesn't. For the purposes of this policy, the CEO is the ultimate spokesperson of the organization, and the chairperson of the board is the spokesperson for the board. However, with all responsibilities delegated to the CEO, she's able to set a designee. In this case, it would be the communications office. We talk about how we're going to manage relationships with our media. We cover items such as if a member of the media comes to our school, come to one of our schools, are they allowed to walk in? Or do we ask them to follow a certain set of steps to get the answer that they're seeking? Where do we drive them to get those answers? How do they know when we're sharing something with them that it's information that's appropriately delivered? This policy sets that relationship. We define how we're going to respond to media in emergency situations. Again, we lack those guideposts right now. So in the case of, let's say, Lord forbid, a fire at a school, and somebody puts a microphone in front of one of our employees, someone can just respond with information that may or may not be correct. There are very serious implications for that. If that information isn't correct, or if that person's not authorized to speak about a situation, or if they say student Andre Riley had a seizure, well, that's violating law. So we need to determine how we're going to respond to media in emergency situations. This policy does that. We also make sure that employees have the right to speak to media and that we protect their right to free speech. In our research, one of the things we found was in some school districts, these policies are used as a way to restrict employees' right to speak to media. Well, we're not really restricting it, only when you're speaking on behalf of the organization. And we work to be very clear on that. And finally, as I mentioned, this policy does not apply to charter schools. It applies to our employees who work in those locations. But because of the different agreements we have with charter schools, it would be hard for us to instantly apply this type of policy to them. That hasn't come forth through my understanding from an agreement. Next slide, please. So when I talk about what will policy KDD accomplish, again, we work on two sides. On one side of the street, we have how we work with our media, with the intent, again, is to have that effective working relationship. And we do that through clarity, a mutual understanding of who does what, who speaks on our behalf so they know who to talk to, and we make assurances that we will be transparent and we will provide an environment where all journalists are respected. And that last bullet is probably the most significant one. Many relationships deteriorate when individuals don't feel respected. By having rules and structure, when we work with any member of the media, they know that we've set forth ways to help them do their jobs while also respecting the organization and our desired outcomes. On the other side of the street, we define how our employees are going to respond to media requests. Again, we respect your right to speak to media within a proper context. We provide an organized method to seek media coverage. Right now, if I work at a school or in the office and I'm doing something great and I want to share that, maybe I write my own media release. Maybe I call my friend who works down in one of the TV stations I hope for coverage. Instead of that haphazard approach, we're saying funnel it through communications. We'll make that outreach for you, and we'll do it in a way that best reflects what media wants, which again which shows our respect for what they do, but at the same time, it allows us to achieve the outcomes we're seeking. It relieves individual employees from conducting media relations activities. We're a strong believer in communications that everybody has a role on our team, a very specific role. And we get in trouble when we start crossing over and doing other folks' jobs. So instead of everyone worrying about media relations, we free them to focus on their work duties by saying we're going to make sure we funnel everything through a source and we provide the media members the best information as possible. And again, finally, we want to make sure that we provide things that are accurate. That is the crux of our brand. We're transparent, we're accurate, and we're fair when you speak to us. And this policy allows us to create an environment that has that. Next slide, please. Again, to hit upon the main standards of policy KDD and its regulation. Again, the CEO is the official spokesperson for our organization. That's always been the understood truth, but we're codifying it. But as always, the CEO has a right to set a designee to speak on behalf of the organization, which he often does. Again, the goal is to codify it. When we talk about bullet number 2, instead of haphazard news releases that don't get to their source, we say that the communications office will work toward that goal, and we'll seek coverage that reflects our outcomes. Again, that organization. So instead of everyone doing everything, we fit within defined roles and we work to achieve the desired result. We're going to help schools share their good news, and that's a big one here. From my time, from the interview process to this very moment, it's been made clear to me that great things happen every moment in city schools, and we need to share those with media. Our job is to set forth an environment of which we can collect that information from our schools and share it. Policy KDD does that. We protect the privacy of students and our staff between FERPA, HIPAA, and just other privacy-related laws. We will be transparent, but we will do it in respect to the law. And this helps the media members understand if we don't answer something the way they are seeking, this is why. And right now, I don't believe that understanding exists based on our current experiences. And the 5th one, as always, in an emergency, we want to be coordinated and we want to have a defined response. And this provides for that. Next slide, please. For feedback on this policy, we did a couple of things. First, we reached out to PCAB parents. While parents aren't directly impacted by this policy because it's more employee-centric, there are aspects related to privacy and procedures and laws that we want them to know that we are protecting and to get their feedback if we need to be more stringent or not. We worked with the respective business units listed. Again, this is an employee-centric policy. So we worked with the Office of New Initiatives to figure out how it would impact charter schools. We are in the process of working with human capital, school operations, and we have worked in a very effective way with legal to make sure we set forth a policy that allows us to achieve our goals. In particular, with our legal affairs office, Josh Sivan and Sally Robinson have been invaluable in finding us examples of other school districts in Maryland and in nearby states that have similar policies that we can apply. So we've been able to add things to make this policy very well-rounded and very broad where it needs to be broad. And we plan to reach out to the employee bargaining units because, again, this is an employee-centric policy and we're sure they're going to have input. We want to make certain that individuals understand the goal of the policy isn't to be super restrictive, but it's just to provide guideposts so when we respond to media, we do it in a very organized way. Next slide, please. And finally, these are our research references. We went across the country, big school districts, small school districts, local ones, not so local ones. And we took bits and pieces of every policy, compared some notes where there's conflict between two different entities to find the best possible approach for Baltimore City Public Schools. And that, board members, is my very succinct presentation. I look forward to your questions.
Thank you so much, Andre. Do we have questions from other board members?
Dr. Brooks, yes. Thank you, Andre, for the presentation. I always tend to wait for Commissioner Chenier, but she didn't pop up. So I'm hoping that this is all right to go before her. In addition to the groups that you listed for engagement, I would just, I know that you mentioned the bargaining units. Principals just ring a very loud bell in my ears in engaging this, because they're often, at least traditionally, if media or folks are coming to the school and if this policy hasn't been in place, so they directly often go to the school office or deal with the principals. So that's just the bell to ring. Also, I would encourage you all to consider specific student groups, particularly the CEO's Leadership Council, getting input from those young people. I would even, because I know that there's diverse representation there, I just think about the march that our students organized a couple of months ago, and how the media was involved in all of that. I don't know how City Schools was as involved in it as I know the students were, but I just know that students, especially now in an awakened season of activism and awareness that our young people have, I would certainly incorporate a lot of their voice in this. So first, they understand the process, but that they also are able to contribute to the process as it's being developed. Also, our student commissioner certainly should be someone that is directly engaged with this. I would also be interested in seeing how we work with, in engagement, how we work with City Hall, the mayor's office, and emergency management, how they could potentially lend feedback and support. We're a large organization, one of the largest city agencies. So I think it's important to make sure that we're cross-functional in our approach so that we can, be on the same page. Can you talk a little bit about the student release, the option for students to opt out, right? Of media. So that deals with photography, their likeness, things of that. I know that we have it in policy, but I would like to just have you go into that a little bit. What is the opt-out process for students?
All right. Right now, when it comes to the use of a student's likeness, whether it be photography, video, or interacting with the media, we use a process that considers that we will do it unless you tell us not to. That's the essence of the opt-out process. At the beginning of every school year, we provide a form and an instruction to families to say, this is what we're going to do. Right now, everybody's all in and we're going to assume it's okay. However, we make you aware of your right to opt out and we provide you a form. In fact, we're revising the one for this school year right now. And if a parent opts out, whether it be at the beginning of the school year or any time, quite frankly, we will honor that. And in this case, if it results, let's say you attend Dunbar, and then you opt out of our policy at mid-year, and then media comes up at the end of the year and says, I want to photograph Commissioner McFadden. What we ask schools to do is, before we invite media on our premises or engage in any photography or videography, to check to see who's opted out. Schools maintain that information, and we make certain that before we allow anybody to be filmed, that we don't have anybody in that picture who shouldn't be.
So schools maintain the opt-out information. I know that there's an opt-out process, but this is a little fresh for me, knowing that schools maintain it. So we don't maintain that information centrally?
No, and I actually believe it's,
yeah, it is an Infinite Campus. I'm sorry, it is registered in Infinite Campus.
Okay, so it's accessible to everyone. Okay, that's good to know. Should we then specify? Should we specify more of the opt-out process for students in the regulation? Or is it Chief Seven, you might know a little bit more, Josh, but is it in another policy somewhere? Does it exist somewhere else? Or would it be smart for us to include this language in the regulation?
I think we can cross-reference. I believe it's in the regulations that deal with student records. It's the standard process under FERPA, which is the Family Educational Rights and Privacy Act. I think I got that right, in terms of opting out. And we've taken that and we've also added into that, more so than actually many other school districts, the explicit provision around media. So we have, we're tying it all together with this policy and regulation. And I see that Sally Robinson turned her camera on, so she may have some help on exactly where it is.
Sally, you're muted.
Sorry, I have one of my policy binders at home. I'm going to look through JRA RA, which is the regulation on student records, really quickly to see if it's in there.
I would be curious to see, yes, after the cross-referencing happens, like if it would be appropriate to include it in the regulation. This is what I'm leaning on you all's expertise to see whether or not it would be appropriate. But I think it's important to make sure that all school leaders and everyone, teachers also, are clear on the process of students opting out, because we are in this age, we're now in the digital age, and there are often times where, you know, likeness, all of that is taken, and sometimes our young people may have opted out, and I just would hate for us to be in a situation, you know, down the line. And to that, our teachers and staff members, so they are not able to opt out of their likeness or any of that being taken. As an employee, they're not able to opt out.
There's nothing in this particular policy that gives them the right to opt out. However, in a more practical sense, we are made aware from time to time that employees would say, I don't want to be photographed. And when they let us know, we do our best to respect that. but there's no formal process that says Andre Riley, the employee, can fill out a form that says you don't have the right to capture my likeness and to use it.
So if you want, I can interject a little bit in JRA -RA, the administrative regulation on page 10 of 11. There's sections K and L. So K references the annual notification of rights under FERPA. So that basically, that's in the family guide that goes out every year, and that lets families and students know what their rights are under FERPA, including the right to come in and take a look at their records, to get an explanation as to what their records mean. Also, the right to request, if they believe that there's some discrepancy or a mistake, not a mistake, but if they feel that there needs to be a correction, there's a process for that. So that's explained to folks every year. Additionally, in section L, there's information about directory information. And it says city schools may disclose appropriately designated directory information without consent unless a parent or guardian or eligible student who's 18 years of age or older opts out of some or all of its release by completing city schools student information contact form. FERPA defines directory information as information that is generally not considered harmful or an invasion of privacy if released. And in that annual notice that we send out, there's a specific form that tells families this school year, city schools is designating the following items as directory information. And typically for years, that's been name, address. I can't remember if it includes telephone number, but name, address, your current school, your current grade, awards and honors received, the last school the school district that you attended before here. And then, like Mr. Riley was saying, they have the option of opting out. And that is captured by the school and entered into Infinite Campus.
Right. So would it be possible to add another safeguard legally to give permission to perhaps the school principal? For example, if a media outlet requested information from for a student per se, right, and they have not opted out, so we can use their information, can there be another layer at least for permission to be granted from the school leader, from the principal, for that information to be released? I just think about young people, and they're very vulnerable, and I just I don't know if it would be legally possible if it isn't in FERPA or wherever, I don't know. But it was just an idea that I had for an extra level of safeguarding our students.
You mean in addition to, are you referring specifically to media requests? Or are you referring more generally to release of
media requests? Media requests.
So they should be going through Mr. Riley's office. So you want to just make it clear that in addition to communications, we would consult with the principal before releasing.
Yes.
That makes good sense.
We can build that in. Thanks, Josh.
And I think that's it. I just want to, I know that you all are thinking about the staff, their protection also. But that raised the flag for me. Like if our students and our young people can opt out, perhaps a teacher or another staff member may want to opt out for whatever reason. It seems unlikely in the digital virtual space, as we're going to be completely remote and virtual in the fall. So I would assume that teachers and staff members and everyone's okay, but I don't know if it is explicit anywhere to at least provide that option to them, and if we are able to do that legally for them. I just thought about that. I think that's it. That's it for me.
Thanks, sir. Oh, I can't hear you. I'm sorry.
This is okay. I don't really have a question. I do just wanted to affirm the idea of really putting the guidelines in writing and being very explicit about them. I think that's been lacking a bit. And a part of what I want, it's a little different than Commissioner McFadden's in terms of for the students, but it's really on the lines of just sort of equity in the way that access for assistance in terms of some of this media access for schools and things, that the office really is conscious of all of the levels and types of programs and things that might come up. You know, we generally always hear about the high school events, you know, the sports, the fine arts program, those kind of things. What we don't always hear as much about, and I think we hear a lot in some cases about elementary. I'm really thinking in terms of the middle grades. We don't hear much about some of that. So I'm just an awareness that we really are showing a well-rounded picture as folks are attempting to find ways of sort of showing off and things that are happening in their schools.
Thank you, Commissioner. That remains one of our principal concerns. Equity across the organization. We have a lot of great schools, a lot of great programs, different types of students.
Mm-hmm.
But right now, we've been very narrow at times with, it's the usual suspects, the usual schools or the usual programs, and we go to the well a lot. But we want to begin to show off all of our schools. As a person who's fairly new to Baltimore, I've heard several schools over and over. And then yesterday, I'm surprised with the name of a school I didn't even know it was ours till somebody said something. They're like, oh, that's your school? I'm like, oh, wow, thank you for that. So it just drives home the fact that we're everyone's school district. That's a key, a bedrock foundation of how we communicate. We're here for everybody, and we need to reflect it.
Great.
So I just have a few comments, and definitely want to leave ample time for Josh to update us on the COVID-19 changes or impacts of the policy. But one of the things that came up for me was when we're trying to put in place the regulation to help teachers figure out if they have an issue or they want to do something with media to like outline that clearly. For me, I didn't see that come through in the regulation around sort of the step-by-step process. If a teacher has an idea that they want to sort of advance, like, so who are they reaching out to? Sort of like, are you all sort of, I heard you mention, Riley, that you all work your magic on it, but like, is there actual process besides reaching out to you all? And then, and if not, or where does that live in the regulation to kind of just, be a little bit more explicit there?
Okay, there is a process, but you're right. It's not spelled out as explicitly in the regulation, and I think we can definitely do that. We have the steps. It's just adding that section to be very clear.
Yeah, because I think because we want folks to be able to easily access it, and so when I think about these regulations, I see them as guides ultimately, and anything that we can do to help people follow along the guide and move along the train quicker, I think is great. One of the other things that came up for me, let's see what it was. There was a part where teachers are presented information at different venues or conferences or that sort of thing. And you say we encourage them to write and to put things out there. Do we already have language for them to say that this is just their thoughts and thinking and not sort of the representation of the board? Do we give that language explicitly to every single one? And
no, but it may be a good idea to put in this regulation, a very specific, just a sentence, because that's all it takes. Yeah, this is Andre Riley speaking on my behalf and not of my employer, Baltimore City Public Schools. It's right. Very clean. And right now, folks do it ad hoc. They use their own judgment to create similar statements, but it'd be great if we just had a very uniform boilerplate. So that's something we can definitely add to this regulation.
Awesome. And I think the last thing that kind of came up for me was when we're doing the what is this? The regulation. So we have our students sort of interviewers and whatnot. So I'm just trying to figure out, like, if someone has these multiple roles, and for example, a teacher somehow, while not on official business, speaks out on behalf of a with press outside of out of school and off their time, but it directly relates to something that is going on that is emergent. How do we address that? And then does that put them in any sort of violation that would sort of lead to any disciplinary actions? And if so, like, what does that look like in the reg?
In the regulation, we're very careful to say that you have that right. Our teachers, for instance, we saw during when the protests were happening a few months ago, you'd have groups of teachers out protesting in support of students. They'd be driving cars, they would drive their cars throughout the community. And we didn't want to silence that. Mm-hmm. All we ask in the regulation states it is you just need to make clear, I'm speaking for me. Mm-hmm. I'm not speaking as Andre Riley, Director of Communications, but Andre Riley, private citizen, has lots of different thoughts. And just because I'm a public relations professional doesn't mean I can't speak on things that I think matter. In fact, I do, quite frankly, outside the organization. So we have a reminder in the regulation that specifically says, just make certain that when you do speak, I'm speaking for me.
Okay, yeah.
That typically is a permissible use. I do not want to stifle one's ability to speak. I just don't want you to represent the organization when you do.
Yeah, that totally makes sense. And I think where I was just coming from was, I didn't want there to be a situation where a teacher actually speaks out on something that was specific to their profession or the district, but they were doing it on their free time.
Oh, and I see. So perhaps somebody says, I don't like virtual learning. Yeah, some reporter comes up to you and they say, will we penalize you for, because that does have to do with the district.
Yeah, so I just didn't know. Right. I just wanted to.
And there's, just to jump in there, there's a large volume of First Amendment cases on where the line is. And I think that just we rather than go into lots that would be inaccessible, we just said consistent with First Amendment law, because if you speak out in a way that would make it would disrupt your ability to continue teaching. You speak in a way that is hate speech, for instance. That may be a different piece than something on a matter of a purely public concern. So just making sure that is all tied in here.
Great. Well, thank you. Those are the questions that I had for that. Thank you, Andre. I appreciate it.
Thank you all. Is there anything else I could do for you?
Thanks, Andre.
Have a great evening.
Thank you.
Or Andre, do you prefer Andre? Do you prefer Mr. Riley? What do you prefer? What is your preference?
I'm Andre. We're teammates. I'm Andre.
Okay. All right.
Thank you.
Take care.
And so we have Josh, I'm assuming, teeing up for our.
Sure. And Shahrazad Houghton is going to go into the details in my office, who should be coming up here. But I just wanted to acknowledge that there's been a lot of work on a very quick turnaround as the recovery plan has been drafted to then make sure that that aligns with all of our policies and regulations, and just to appreciate the space that the commissioners have given a policy committee, both in June and now here, to emphasize the importance of making sure that everything we're doing is consistent with policies and regulations. So that has really been baked into the work we're doing. And I think I stalled enough so that Shara can start with the presentation.
Can everyone see my screen?
If you could speak up a little bit.
Okay, sorry about that. I was saying, can everyone see my screen?
Yes.
Yes.
All right. So Josh gave me a brief introduction. Some of you have met me already. I'm Shahrazad Houghton. I'm assistant counsel with the Office of Legal Counsel. So at the June Policy Committee meeting, we presented to you guys our comprehensive review of some of the policy implications as it relates to COVID-19. And also, we gave you some updates on a number of initial revisions that were made to some of the regulations, such as BCARA, which is the conflicts of interest, and IKARA. So we have since then made some updates to the charts that we have, initially presented to you guys based on subsequent developments in the recovery plan that was posted on August 14th in compliance with the MSDE requirements. And so I want to thank you guys because the June presentation to the committee helped to ensure that the policy and the regulation implications were taken into consideration with the recovery planning. So some of the ongoing developments are that our charter school application process waiver is still pending with MSDE, and some other key changes will be tackled in the policy developments in the coming months. So for instance, you all just saw the presentation for copyright and intellectual property, and we'll be updating the staff misconduct policy. So in the initial presentation, some of the policies and regulations were labeled high priority. And as you guys may recall, the high priority policies and regulations were those that we had deemed required action prior to the start of the school year. And they were IKEB and IKEBRA, which is graduation standards, JEA, compulsory attendance, EEARA, eligibility for transportation services, and JECRA, procedures for early admission to kindergarten and first grade. They're no longer marked as high priority because through our recovery planning and our implementation of, for instance, the early admission to kindergarten, we have addressed those things and we have done it in a manner that is consistent with our policy and regulation. However, as it relates to IKEBRA, you'll see later that has actually moved to a medium priority. And just again, you guys may recall based on the key that a medium priority policy or regulation was one that would be addressed throughout the course of the school year. That particular policy and regulation has moved because we are still waiting for information from MSDE related to that policy and regulation, because simply as it relates to that policy and regulation, it's mostly just state law that's codified into our own policy and regulation. So it's controlled by the state, and so we have to wait to see what the state of Maryland is going to do in relation to that. So some of the policies and regulations that were previously labeled as medium priority, it's quite an extensive list. So ABH, community school strategies, BEA, regular business meetings, BLA, procedures and appeals and hearings under 4205, BLB, procedures and appeals and hearings under 6202, BLC, procedures and appeals and hearings under 7305, IDMA and IDMA-RA, JFB, RA, student enrollment, JKARA, classroom management and student behavioral interventions, JKARB, student suspension and expulsion, JRA, RA, maintenance and release of student records, KCA and KCARA, family and community engagement, and KCB, KCBRA, volunteers. These particular policies and regulations are no longer listed as medium priority and have moved to a low priority because we have addressed those things, again, either in our recovery plan or in our implementation of just how we are carrying out those policies in a manner that's consistent with social distancing requirements. So there are some policies and regulations that remain medium priority, and they are ADFRD, student support services, EGD and EGDRB, internet safety and acceptable use of technology policy, GBEBB and GBEBBRA, staff conduct with students, GCLE and GCLE-RA, telecommuting, IKEB and IKEB, graduation standards, which is one that I referenced earlier in the presentation, JFBA and JFBARA, school choice process and entrance criteria, JLCDBRA, anaphylaxis, and IKBRA, sex offender registry. So what are the next steps? So the recovery plan has addressed many of the medium priority policies, as I noted earlier in the presentation, but those that remain medium priority will be brought to the policy committee over the course of the fall, and we will continue to track the recovery planning and collaborate to review potential implications. And as updates become necessary to our policy chart, we'll continue to update you all.
Great. And you said it's Shahrazad?
Yeah, Shahrazad.
Shahrazad. Thank you so much for the presentation. And I guess Chair Chinia and Commissioner McFadden, questions, comments from you all, and I wasn't even sure if this was just a space for us to be an open discussion about just sort of the changes that we've seen, given that we didn't, we don't have access to all of those policies in front of us. But yeah, so.
And there, I should add that there's a detailed chart that goes into all the policies as well, and the backup behind this for you all to peruse at your leisure, and for us to continue to flag, because we all know that things are subject to change as they go along.
I appreciate that. We perused it. I'm looking right at it, and I see the difference. I see the difference. There is no red, right? So I think that is something, it's a sigh of relief to a degree. But my question is, what will be our process for amending these policies throughout the course of this year? I know that you all are going to bring them back to the policy committee for us to have discussion around them. I'm just curious to know what will that look like? So as we see these medium priority policies, is staff going to go through them? And how will they be weighed on when they come to us? I think that's another question, if I'm making sense. Am I making sense?
Absolutely. And Shara can chime in, but I think that some of them have already been scheduled for the course of the year. I'm thinking of the staff misconduct one is already on the list. Some, you just talked about one before, the copyright one, which would have been read, but we're moving it through. And others, I think that the priority will be around as we get into the semester, the urgent, if there are particular pieces that are have-to-haves versus nice-to-haves. So we're going to prioritize the have-to-haves before the nice-to-haves.
Could I add to that if you can also sort of weigh in on, some of this is also going to depend on what format we're in. If we move into some sort of small group or hybrid versus if we move into a full hybrid versus if we move into in-person. So some of that I think would also put the priority on some of them quicker than others, if that makes sense at all. So
it makes complete sense.
Yeah, so I think it's going to require a lot of flexibility and continuous review on all of our parts.
One of the ones that Shar and I were talking about, and she may have mentioned it, was around athletics, and we thought that may have been one that we had to move more quickly on, but then the state MPSSA made their effort. So again, I think that with the dynamic nature of what we're going forward, Shar did a good job at teeing up. Similarly on the charter pieces, that we're continuing to watch that application process and how that works as well.
Right.
And I think for me, I just, and this is, really leaning on you, Ronald, or Commissioner McFadden and Chair Chinia, as a policy committee, like when things are we looking for these updates to be more of like a conversation or a dialogue around sort of what needs to be amended to make sure that we stay in compliance? Or are we looking for more just an update around sort of how these things are moving forward? And if we needed a flag to say, well, this actually needs to get like done immediately versus just as an update. Yeah, so I just wanted to be sure, because I wasn't clear, like, what functionality we were going to do that, for that form.
I actually see this as sort of I'm sorry, I'm in the house alone and I try to turn off my other phone, so it'll stop ringing in a minute. I actually see this as a part of the ongoing process that we've been doing. I mean, we've been getting regular updates on what we've called either the COVID or the recovery plan. And so and it's been interesting joining policy at this time. And thank you for the charts. But I actually see that paired with that ongoing review, because we're going to have to look at the recovery plan constantly. Again, based on, what data tells us about what's happening and what needs are, as we look to see how that plan evolves. And I think we have to look at the same time at which policies pair up with that, and what, if necessary, might we need to be doing. Yeah. So it may be a little different than the policy committee timeline has been before, but I think it's what we're going to have to do for this year.
And I think we would welcome reserving a bit of time on the policy committee meetings in the fall, because I think that, frankly, we've benefited from good eagle eye spotting by commissioners over this process, focusing on, Shara mentioned the wellness policy, making sure that's aligned. I know we had a little bit of conversation at, I think, the prior meeting about the patriotic exercise policy, that easy one to, but we made sure that we addressed how that all fits in. But I think the more eyes in this crazy time that we have, just making sure that we spot, and that's why even the list of policies is helpful, because some of them don't come trippingly even to my tongue or to Shara's tongue, but making sure that we have the discipline of focusing on this and updating and checking, I think is a really good part of the work that we can all do together.
Yeah, and that sounds good and right for me. I think as we begin to move into our fall policy calendar, we're already going to be into some discussion around sort of making changes. Definitely, we can carve out time to do an update to make sure that we have those. But as Chair Cheney has suggested, that maybe there might be other policies that we might need to shift around to just kind of make it seem more in real time versus the formulaic way in which we kind of structure things. Also keeping in mind that we want to ensure that we don't overburden staff with like last minute requests or changes or things like that. So, yeah, that's.
To add that, we welcome feedback from you guys, as Josh had noted. But as Chair Cheney had noted, this is essentially, a living, breathing document, and it is an ongoing process because the nature of COVID is so unpredictable, and at any given time, things can change. And so as things change because of COVID, whether they get better or worse, that may impact, where some things go in relation to this chart. So, it is not meant to be, just a here you go, because that is just not the nature of the world that we live in right now. And these are very unprecedented times and uncharted territories. And so we will all constantly be brainstorming and figuring out ways to navigate this. So it's a team effort.
Great. Yeah. And so if there are ways in which we as as a committee can be helpful in doing some of that thought partnership, clearly we are more than welcome to join in. And I think the updates are really helpful for us. And I know that one of our concerns was really making sure that we're not out of compliance. And so with our policies and that sort of thing, and it's really helpful to see that even in the midst of a pandemic, we've been able to minimize the high priority areas through some really intentional thinking and planning, thoughtful planning. And then, as things come up, we can, I think we're committed, I'm committed as the chair of the policy committee and all the staff to doing what we need to do to make it as we ride this wave together. So So yeah, so I didn't know if there were any other pieces around a conversation that we wanted to have with Josh and Shahrazad. I'm going to get it. I
appreciate the work that the team has done. I just want to celebrate that. I know that this was a pretty urgent, request. I mean, for all of us, but the committee requested that this come before the board. So I appreciate the thoughtfulness that has come with this, the removal based on our recovery plan of what is no longer high or medium. I think that is very helpful for me, and I think it's helpful for the full board. So I just appreciate you all for the work. Thank you.
Absolutely, you're welcome.
Yeah, I would, and I would also suggest, that we be certain that the board is aware that of the list and that it's available, and everyone really, I think, should take a look at it and use it as we are continuing our reviews. So Mr. Chair, Dr. Brooks, if maybe you can remind folks of that at our executive session. I know it may be additional reading, but I plan to put it side by side with my recovery plan. So as we sort of go through, I'll have the two documents there.
Great, absolutely. Absolutely, we'll add.
And thank you again. That really was great work. Thank you.
I'll wait for the
chicken. So, if that's all,
I'm cooking dinner. I'm sorry,
and
it's ready, but they're okay.
So if there are no other comments, I think we'll move to close the meeting. There are a couple of updates before we do that. So I just wanted to update folks that our next policy committee meeting is going to be on September the 15th from 3:30 to 5:30. And of course, that meeting will be virtual. And you can all do for public comments if you want to sign up. That is available from 9 a.m. on Thursdays before the policy meeting up until Monday at 5 p.m. And we really do and welcome and want public comment on these policies. And you can reach out to our school board web email address to actually get signed up for our virtual, to speak on our virtual meetings. And so if that is it at 5:17, I would close this policy meeting and thank everybody for their time and energy and commitment to the work. So
thanks, Dr. Brooks.
Thank you all so much.
Thank you. Good evening.
Thank you. Good evening, everybody.